Welcome to Washington in Focus Daily. It's Tuesday, March 24th, 2026. I'm Carleen Johnson, the Center Square's state government reporter. And in today's episode, I know, is this getting repetitive? The income tax watch is still on. There are no plans on Governor Ferguson's schedule today to sign Senate Bill 6346, the millionaire's tax. At least it's not on his calendar. State GOP Chairman Jim Walsh had a conversation with me today, basically sharing his speculation that the governor is delaying signing this to kind of eat up time that opponents could have for a citizen initiative to try and reverse the income tax. Now, if in fact that were to be launched this year, there's still a lot of unknown whether or not that's going to happen this year. Could also be some legal challenges coming as opponents contend that the income tax is unconstitutional. Huge case argued before the Supreme Court, U.S. Supreme Court on Monday that could have some dramatic consequences for how Washington state runs elections. This has to do with when ballots have to be in to be counted here in the state of Washington, so long as you've got it in a drop box or it's got a postmark for election day forward, that ballot can be counted right up until certification. And so this, of the arguments that took place before the U.S. Supreme Court yesterday and their decision, which is expected probably by very early summer, could dramatically change how elections are run in the state of Washington. So GOP Chairman Jim Walsh weighs in on that one as well. And then finally, there was a big win Monday for Undivided podcaster Brandy Cruz and her legal team with Citizen Action Defense Fund in a case over public records the city of Seattle delayed providing her. Jackson Maynard with CADF has the details on that for us. So let's get into it. Income tax bill not yet signed into law, Senate Bill 6346. Nothing on Governor Ferguson's calendar showing he'll sign it today. It is not on the list for two bill signings, the way it's kind of been going the last several business days of bill signings is he has one session in the morning where he signs, 10 to 20 bills and another one in the afternoon. It's not on the radar today, although today he is signing the rollback of the estate tax increase, which many say is basically a concession without verbalizing it that there's such a thing as wealth flight, capital flight, when people want to avoid, the wealthy want to avoid those kinds of taxes, like the income tax is about to implement. It is not, again, on the list for today. I keep checking every night, so we're going to be right on top of that. But GOP Chairman Jim Walsh today told me his speculation is, in fact, that Governor Bob Ferguson is delaying signing maybe up until the last minute, which would be April 4th, to lessen the amount of time that opponents would have for launching a potential initiative to repeal the income tax. Because until they know exactly what Ferguson signs, as there could be some sections that he vetoes, they can't really strategize, how that initiative is going to look. So here is Chairman Jim Walsh.
On Senate Bill 6346, that's the state income tax scheme, they put, of course, what they call a necessity clause on it. Not exactly the same as an emergency clause, but effectively the same. So that's kind of issue one. And you may see a lawsuit about that because it's pretty dodgy how they put that on there. And they is primarily state senators Peterson and Frame. They're kind of the tax gurus for the Democrats in Olympia. So they put this necessity clause on the state income tax bill, but the state income tax doesn't take effect until 2028. So why is there urgency on this if it doesn't take effect for a couple of years? So we could make the argument, try to get a court to strip that off. I don't know how strong that would be. But that necessity clause means a referendum is not possible, but an initiative is still possible. Referenda are easier. They require fewer signatures to qualify, and the timeline on a referendum is a little more favorable for quick action. On an initiative, the timeline is a little less favorable, and you need to get more signatures to qualify it. But we could still do an initiative. The necessity slash emergency clause doesn't affect an initiative. It only affects a referendum. So we could do an initiative to the people this year. We have until the first few days of July to collect the qualifying signatures. So it's a tight window, but it is doable. Um, we don't, one of the problems is the governor hasn't signed the bloody thing into law yet. So you can't really get an initiative repealing something going until you know exactly what the something is. And of course, because the governor in Washington state has what's called a section veto power. It's not a line item veto, but it is a section. The governor can veto a part of a bill and then sign the rest into law. Because the governor does retain that power, we can't be sure what the final form of the state income tax scheme would be.
So again, the wait on the governor's signature continues. Plenty of rumors out there about an initiative effort. Will that be launched this year? Will that be put off till 2027? We're in the know, and I'm talking with folks who are part of that decision making process. So stay tuned for updates. As soon as we know, you'll know. Now, to Monday's Supreme Court case, there were arguments with a challenge to a case out of Mississippi. So, in Mississippi, the law concerning Election Day allows that mail in ballots can be counted so long as they're postmarked by and then received within 5 business days of Election Day. So, maybe you were out of state when you filled out your ballot, you drop it in the mail somewhere else, so long as it's got the postmark of that day going through the postal service, it's going to be counted so long as it's received within 5 days. So, a majority of justices in the arguments that were heard before the Supreme Court yesterday, according to a SCOTUS blog report and a summary of how the arguments went, basically said, I think the justices agreed with the challengers, which were the Republican Party of Mississippi, a Libertarian Party group as well. If this in fact goes, um, if the court ends up siding with the challengers, this is going to impact how election days go across the country. And Washington state, it turns out, is really an outlier in how we do it because so long as you've got that ballot into a drop box or has a postmark for election day, it can be counted right up until literally certification weeks later. And again, that really makes us an outlier. The ruling could be coming by late June, early July, most likely when cases are argued this time of year. The Supreme Court issues those rulings, a few months later. So that's what the anticipation is. So then it's going to affect the November 2026 elections. And they're going to have to make some adjustments in the office of the Secretary of State here and how all of this works. So here is State Republican Party Chairman on the significance of this case. Here's Jim Walsh.
The U.S. Supreme Court case is a huge deal for Washington state's elections. The case itself is out of Mississippi, but it hardly matters. The U.S. Supreme Court's ruling on it would affect elections everywhere in the United States, of course. Uh, and what the gist of the case is about is how long or can you at all accept mail-in ballots that are postmarked by election day, but not received until after election day. And Washington state is a massive outlier in this. Most states, well, I should back up. Many states say that mail-in ballots have to be received by the auditor or the election office by election day. And that's the safest and the most transparent way to treat mail-in voting. Some states allow uh, ballots, mail-in ballots that have been postmarked on election day to be counted if they're received after election day. But most states put a time limit on that. They say it's 3 days. In the case of Mississippi, I believe it was 5 days. And that's the case that's being considered by the U.S. Supreme Court. Washington state allows ballots to be late arrivals until the election is certified. That's 21 days normally after election day. That's outrageous. I mean, Washington state is reckless and extreme in its position about that.
I reached out to the office of Secretary of State Steve Hobbs for comment and received a statement that says, in part, you can read with me. In 2024, approximately 127,000 voters cast a ballot that was postmarked on or before Election Day but received after Election Day. In Washington, those votes are counted. Now, he went on to say, or the statement, I should say, from the office of Secretary of State Steve Hobbs went on to say, if the Supreme Court decision does indeed enforce a total ban on ballots received after Election Day, he says they'd be ready to, increase their existing efforts to ensure that voters understand what their options are. But it would be a big change for here in Washington, since from what Chairman Walsh told me, there's no other state outside of Washington that allows those ballots to be counted right up until certification. So it would be a dramatic change for us here in Washington. So stay tuned for that. Also, Shasti Conrad, who is chair of the Washington State Democrats, sent a statement. I want to show you part of that. She doesn't make any bones about it here. She's not very pleased with the direction of the case. The mega conservative Supreme Court putting their fingers on the scale mere months before elections are to be held will cause chaos, disenfranchise voters, and cost millions of dollars that states don't have. Washington voters chose our vote by mail system, and it has been working flawlessly for decades. Our elections system is the best in the country. Again, that was from Shasti Conrad, who is chair of the Washington State Democrats. So, again, that decision from SCOTUS likely to come late June. Late June. I just put June and July together there, didn't I? Late June or early July, and it will then have an impact on the November elections for certain. All right, now to a big court victory for Citizen Action Defense Fund that came on Monday, along with Undivided podcaster, Catiff's client, Undivided podcaster, Brandy Cruz. This was a fairly significant case when it comes to public records. Let me give you a little bit of the background, and then I'll share some of the conversation with Jackson Maynard with Catiff. This was an appeal in a public records lawsuit against the city of Seattle. And then the ruling from the appeals court affirmed basically that government agencies, you can't evade your obligation to provide public records under Washington State's Public Records Act, the PRA. That reinforces the principle basically that transparency is not optional. And in order to, make people believe that they can trust government officials, you need to provide those documents, when reporters or even Joe Public reaches out for a copy of them. In this case, the city of Seattle, it appears, at least according to the court, went out of their way not to provide the documents in a timely fashion. So here is Jackson Maynard with Catiff sharing background on the case. We spoke this morning.
Brandy was covering as a political reporter the council meeting in which the Seattle City Council was going to take a really controversial vote on whether to criminalize drug offenses, within the city. And there was a lot of opposition, there was a lot of support, kind of back and forth. And one of the primary folks who had indicated he was going to vote in favor of this measure, and then at the last minute changed his votes, was former council member Andrew Lewis. And so she got curious as to what had caused him to change his vote. And, as she put it, her reporter senses were tingling. And so it was like, all right, I need to check into this. And so she asked for a fairly narrow request. She just asked for any emails he had received on his public computer, public email account with publicly assigned cell phone, and any text messages he had received. She just wanted to see who was contacting him. And the problem with the city's response is they said, well, the first installment will be available after August, which happened to be after the primary in which the council member was going to be. And then, probably most troubling, the second installment was not going to be available until mid-November, after the general election in which the former council member was going to be.
So Catiff won multiple motions at the trial court level originally, and then surprisingly, the Superior Court judge ruled in favor of the city of Seattle in some of the cross motions for summary judgment last year. And so then the Citizen Action Defense Fund on behalf of Brandy Cruz, went back and appealed after the lower court's ruling, basically saying the city's conduct undermined the letter and the spirit of Washington's transparency laws.
We had argument last November, and I felt like it went really well. The judges were asking good questions, and the city seemed to be not able to come up with good responses to some of the questions, but that's never an indication. You always want to get the order, and we got the order yesterday that we won. It was a unanimous opinion from Division One. And basically, they found that the first installment, they said, well, because that came within a matter of weeks, that probably was okay. So we're not going to find there's a violation there. But they did find a violation for the second installment, and they also found, based on the evidence of the city's failure to follow its own policies, that they did not act with reasonable diligence, which was one of our other issues we'd raised. So big win yesterday, big win for transparency, big win for public records. It comes in the end of Public Records Week and Open Government Week last week. So it was a nice way to celebrate that.
I did also receive, just a few minutes before this podcast, some comments back from Brandy Cruz, who was the plaintiff in this case. She was very pleased. She said, basically, this is one of many rulings against whether it's the city of Seattle or other defendants in these cases where public records are being withheld or delayed or strongly redacted, as is often the case when we at the Center Square attempt to get public documents from state agencies or officials. So to be fair, though, Cruz and Maynard, Jackson Maynard both pointed out that this is not a reflection on the current administration and new Seattle Mayor Katie Wilson. This was the prior administration under Mayor Bruce Harrell. The bottom line is, Jackson Maynard said, when the government tries to withhold information or delay access, it erodes the public trust. So he's hoping that this new administration under Mayor Katie Wilson will kind of look at this case, note the ruling, and abide by the city of Seattle's own policies on providing public records. All right, so that is a wrap on today's episode of Washington in Focus Daily. I thank you for watching. Ask you to check out the Center Square's Washington page, thecentersquare.com/Washington, for more stories like this. Thanks for watching.